Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, everyone. Another hefty week of cases, diving deep into complicated precedent. And I've got something special for you halfway through the show. Before I get to that, I can't help but note that earlier this week, none other than the official Twitter account of ICE liked a tweet, or should I say an X'd by another attorney promoting the podcast. Thanks for the tweet as always, and thanks for the heart, ICE. Whoever my ICE listener with access to ICE's Twitter account is, this one's for you. Dare I ask for a retweet? With comment. Also, before getting to the cases, I want to tell you a little bit about our colleague, Breanna Cary. It's a little thing I'm going to do for a few months here to promote the bar and all the wonderful work we do. If you haven't heard about Breanna, you should. Breanna is an independent contract attorney who has spent her career focusing on immigration. She can work with anyone, anywhere, and she's worked with many reputable immigration attorneys throughout the country. Like the relief pitcher or closer in baseball, Breanna's passion is to write the briefs and argue the cases. But unlike the closer, Breanna does it under your name, because she doesn't care about taking the credit, just helping you and your client. If you need briefing or case prep and removal defense, federal litigation, petitions for review, asylum, and I-601 and 601A waivers, considering reaching out to Breanna at bcary.law@gmail.com. That's bcary.law@gmail.com. I'll put her email in the show notes too. Now, a bunch of cases for Breanna to use. Our first case is matter of JGR, published by the BIA last week. So as I mentioned last week, this case was published last Friday by the BIA. It's about Convention Against Torture Protection. And it comes to the BIA on remand from the First Circuit in Reyes v. Garland, episode 112. So this is Reyes. The BIA has similarly remanded the case to the immigration judge. The respondent is an asylum seeker from the Dominican Republic. Summarizing his claim briefly, as we went into it in depth more on the First Circuit decision, the BIA states that, quote, the respondent claims that two men wearing police uniforms detained him in a police station in the Dominican Republic, stabbed him with a screwdriver, and ordered him to repay money that they claimed he owed to a local business owner. He testified that the men later shot him because he was unable to repay the money. He was hospitalized and then released into the custody of the same two men, who again stabbed him with a screwdriver. End quote. More details in the First Circuit's decision. The immigration judge denied everything, finding the respondent not credible. On appeal, the respondent challenged only the credibility finding and the denial of cat protection. The BIA affirmed, the First Circuit remanded, and before remanding itself, the BIA explained some things. To get cat protection, an IJ must find it more likely than not that a non-citizen will be tortured by, quote, or at the instigation of, or with the consent or acquiescence of, a public official or other person acting in an official capacity, end quote. Torturous conduct committed by a public official who is, quote, acting in an official capacity, end quote, means acting under color of law. But such conduct by an official who is not acting in an official capacity is not covered, explained the BIA. Now, before I continue on here, the BIA notes in a footnote that this distinction does not apply in the Ninth Circuit. Quote, the Ninth Circuit does not recognize a distinction for purposes of cat protection between public officials who engage in torturous conduct in an official capacity and those who engage in such conduct for purely private motivations, end quote. That's Barajas Romero v. Lynch. To be honest, I kind of also thought that's what Attorney General Barr said in matter of OFAS, but I'll learn why I was wrong in just a sec. In the 2020 decision matter of OFAS discussed 2 weeks ago in the 10th Circuit decision, Attorney General Barr overturned the BIA and explained what under color of law meant. Attorney General Barr explained that for cat purposes, there is no distinction between torture by low-level and high-level officials, and that there is no rogue official exception. Rather, as discussed in that 10th Circuit decision 2 weeks ago, quote, an act is under color of law when the actor misuses power possessed by virtue of law and made possible only because the actor was clothed with the authority of law, end quote. I guess even that doesn't apply in the Ninth Circuit. I guess that's what the BIA is saying in that footnote. But for all other circuits, to me, I thought that was pretty clear. But the BIA believes that more guidance is required. According to the BIA, Attorney General Barr agreed that the under color of law and official capacity framework was the correct one, I guess unlike the Ninth Circuit, and that the standard should be similar or identical to the under color of law standard traditionally used in civil Section 1983 suits that are applicable when individuals sue the U.S. government for torts or other misconduct. The BIA provides quite a few standards for what all that means here. I appreciate the decision written clearly for purposes of guidance. Quote, an act that is motivated by personal objectives may be under color of law when the actor uses his or her official authority to further those objectives, end quote. All right? To the BIA, the inquiry comes down to, quote, whether he or she was only able to accomplish the acts of torture by virtue of holding official status, end quote. Only is quite the word to include that I don't love, but let's see how it all plays out in the coming years. One way to figure this out, quote, whether the actor's government connections provided physical access to the victim, or to the victim's whereabouts, or other identifying information, end quote. To be honest, it kind of sounds like many cat cases that I've discussed on the podcast involving corrupt police. Also relevant, though expressly not dispositive to the BIA, is, quote, whether a law enforcement officer was on duty and in official uniform at the time of the torturous conduct, end quote. The fact that that's not necessarily dispositive cuts both ways for non-citizens. Quote, another relevant consideration in determining whether an official's conduct is under color of law is whether the official threatened and had the ability to retaliate through government channels if the victim reported the conduct to authorities, end quote. All of these are standards to use. And remember, if you want to think outside the box, counsels, I'd expand my case law research to all the thousands of Section 1983 adjudications in your circuit, analyzing the under color of law standard in a manner that you believe is favorable to your case. Those decisions are totally applicable. At the end of the day, the analysis is fact-intensive, explained the BIA, and permits consideration of circumstantial evidence. I'll conclude with the BIA's full quote as it's more important than my paraphrasing. Quote, in sum, the key consideration in determining if an official's torturous conduct was undertaken in an official capacity is whether the official was able to engage in the conduct because of his or her government position, end quote. And in making that determination, the IJ should consider all the things that we just talked about. I hesitate remembering that so many people applying for cat protection are fleeing persecution and torture, and many don't have attorneys, and non-citizens always have the cat burden, even if they suffered past torture. So some of this seems quite difficult for a non-citizen to prove. That is, the motivation and ability of alleged government actors doing terrible things in countries worlds away. The BIA remanded for further consideration on the CAT issue. So congratulations again to Ethan R. Horowitz for respondent. And here's a bit more from what the First Circuit said on episode 112. Looking at my notes, it seems to me that the First Circuit's decision in this case was largely, if not entirely, actually all about adverse credibility. Unsure if credibility is therefore back on the table before the IJ on remand. I assume so, because the IJ here needs to investigate now why the men in cop uniforms were stabbing the respondent with screwdrivers and how they were able to do so. Well, if that is the case, recall that the respondent argued to the BIA that the IJ's demeanor finding was premised on a, quote, unconscious bias against trauma survivors, end quote. An argument that is thinking way outside the box, and that the First Circuit, where these proceedings originate, was all ears on in August 2022 in the decision Rivera-Medrano v. Garland, episode 122. And that is matter of JGR. Next is USA v. Campos, published by the 8th Circuit on August 15, 2023. This is a sentence enhancement decision about controlled substance trafficking. We're going to dive into some criminal for the next couple of minutes. The defendants here tried to sell meth to an undercover cop in Texas and got convicted of a bunch of federal crimes. As relevant, at least two of the defendants had their sentences enhanced based on a finding by the district court judge that their prior convictions under Texas Health and Safety Code section 481.112 were, quote, controlled substance offenses, end quote, that therefore permitted their criminal sentences to be enhanced by a lot of months. By the way, one of the ultimate sentences was 30 years to life. My goodness. To qualify under this sentence enhancement provision, the state conviction must criminalize, quote, the manufacture, import, export, distribution, or dispensing of a controlled substance, end quote. And that includes aiding and abetting, conspiring, and attempting to commit the offense. Really, I'm talking about this case right now because it's the same categorical approach at play as we use in immigration crimmigration, and because the controlled substance definitions have overlap between the sentence enhancement and some immigration provisions, including INA Section 11843B, drug trafficking aggravated felonies. Also, because the defendants here won in a manner favorable for non-citizens. The categorical approach limits the court's review of the Texas offense to the least culpable conduct criminalized in Texas, that prior conviction that now is enhancing the defendant's federal prison sentence by many, many months. Now, Texas Health and Safety Code, section 41.112A, criminalizes, quote, the manufacturing, delivering, or possessing with intent to deliver, end quote, a controlled substance. Seems pretty similar to what's required to enhance a sentence federally for drug trafficking, no? Maybe not. Texas criminalizes delivering or possessing with intent to deliver, in addition to manufacturing. The federal provision that I just quoted does not, although maybe that stuff is encompassed by the distributing or dispensing in the enhancement provision. Get to that in a sec. But even if Texas criminalizes more things than the text of that enhancement, even if the Texas statute is overbroad, it only matters if the Texas statute is divisible. That is, if delivering, possessing with intent to deliver, and manufacturing, as criminalized in Texas, are separate elements, rather than mere means of committing the Texas offense. They're means, said the 8th Circuit. Pretty easy to conclude, by the way, because the Texas Court of Criminal Appeals said as much in Lopez v. State in 2003. That permits Texas to criminalize more things and jail more people for drug crimes, but it has the opposite effect when federal courts apply the categorical approach, because it means that the Texas statute can be violated in many ways, without the prosecution being burdened by having to prove which one, that is, manufacturing or possessing with the intent to deliver or actual delivering. The categorical approach, though, requires narrow specificity. The price states pay for overcriminalizing things is that federal criminal sentences are sometimes not enhanced, and sometimes non-citizens get off the hook. Anyway, that means that the statute is not divisible. All those things are only means of committing one single element in Texas. The federal court cannot look and see which one of those three things the defendants actually did in Texas, and must assume that their convictions occurred based on the least culpable conduct criminalized. According to the defendants, the least culpable conduct is a, quote, offer to sell, end quote, without actual sale. And apparently everyone agreed that that would travel under a delivery theory, and delivery actually can match the federal sentence enhancement dispense or distribute definitions. Unsure why, and this is not my fight as an immigration attorney, but whatever, that's our playing field. But to the Eighth Circuit, that meant that the matter comes down to whether an offer to sell conviction under this Texas statute, quote, invariably requires conduct that is equivalent to an attempt to distribute or dispense a controlled substance, end quote. It does not, said the Eighth. Because even though the sentence enhancement, again, this is our federal provision, includes attempts, the federal attempt requirement at play requires that the defendant, quote, 1, intended to distribute or dispense drugs, and 2, took a substantial step towards that end, but did not complete the intended transfer, unquote. In contrast, though, remember, Texas criminalizes a bunch of things, and there have been many convictions in Texas where the defendant had no intent to actually sell the drugs, but was convicted anyway. After, quote, a thorough review of Texas case law, end quote, so you don't have to, the Eighth Circuit describes convictions for selling to undercover cops, counterfeit heroin. So that's not a controlled substance, or even an attempt to do so. In another case, the defendant offered to sell drugs to another guy just so he could rob the guy, and not with the intent of actually selling the drugs. He just wanted to rob the guy, and he brought a fake package of cocaine to that end. So I mean, not great, but also not an attempted controlled substance offense under federal law. Another guy tried to sell bricks of flour. The cases go on and on. All that's required to convict in Texas is a defendant who, quote, intentionally offers to sell what he states is a controlled substance, end quote. But that is more than what federal attempt requires, at least in the sentence enhancement context, because the federal definition requires an intent to distribute or dispense drugs, not flour. There was more too not relevant to immigration. But the defendants won and will likely get their sentences reduced. And the Eighth Circuit, perhaps surprisingly, continues to publish some of the friendliest controlled substance type precedent. Judge Gratz dissented. Now to immigration. I wanted to do this case because it just seems important, and maybe in ways that I haven't even thought of yet. It certainly explains a lot of what's required of Texas Health and Safety Code Section 41.112a, which I can only imagine is an oft-charged statute in Texas. It also makes clear that delivery is an indivisible means of the statute, which, if I recall my crimmigration correctly, should mean that the conviction can never be an INA Section 11843B Ag Fel, because delivery doesn't require remuneration. Make sure that that's the case in Texas, but I bet it is. And really, that's not even the Eighth Circuit's decision. That's Lopez from the Texas State Court in 2003. Not only that, this case will permit all those Texas Padilla attorneys to point to actual cases where the Texas attempt statute is applied in an overbroad manner vis-a-vis the attempt definition used in the federal sentence enhancement context. And if that attempt definition is the same as the one used at, say, INA Section 11843U or other areas of immigration law, well, we've got ourselves quite the complicated winning argument, it appears. Again, this Texas statute does not require any intent to commit a controlled substance offense when it's premised on an attempt allegation. And finally, as I saw in a footnote after writing the above, this decision conflicts with the Fifth Circuit's decision in Ochoa-Salgado v. Garland, episode 64, where the Fifth Circuit held that, quote, an offer to sell offense under section 41.112a categorically qualifies as an attempted transfer of drugs under the Federal Controlled Substance Act, end quote. The Eighth Circuit thinks that the Fifth Circuit is just flat out wrong, and is reading Texas state case law wrong. And to be honest, with all the decisions reviewed by the 8th Circuit here, it sure seems like the 8th Circuit has it right. Do what you will with that, 5th Circuit practitioners. And that is USA v. Campos. Sticking with crimmigration and the 8th Circuit is Green v. Garland, published by the 8th Circuit on August 16th, 2023. This case is about crimes of violence and such. Mr. Green married a U.S. citizen and became a lawful permanent resident. He did not naturalize. He should have, because about a decade later, he and his accomplices robbed a delivery van belonging to an ATM vendor. He pled guilty to 1 count of Hobbs Act robbery, a crime we always see in the sentence enhancement context but really never in the immigration one. And he spent 5 years in prison. An immigration judge and then the BIA believed that the conviction was an aggravated felony crime of violence as defined at INA Section 11A43F and 18 U.S.C. Section 16A. The 8th Circuit agreed. To qualify, the state or federal criminal offense must necessarily have, quote, as an element, the use, attempted use, or threatened use of physical force against the person or property of another, end quote. Among other things, Hobbs Act robbery in turn requires proof of a, quote, unlawful taking or obtaining of personal property from the person of another against his will by means of actual or threatened force, end quote. Which is why the 8th Circuit and probably every circuit have long held that the statute is a crime of violence in both the sentence enhancement and immigration context. Hobbs Act robbery was pretty much an open and shut issue. But the Supreme Court published United States v. Taylor in 2022, ruling that attempted Hobbs Act robbery is not a crime of violence. Quote, same issue, different crime, said the 8th Circuit. Not going to win the day here. Because the whole reason the Supreme Court said what it said in Taylor is because, quote, an attempt requires only a substantial step towards the robbery, which may, but does not always, involve an actual attempted or threatened use of force, end quote. Completed Hobbs Act robbery, in contrast, requires an actual robbery through use or threatened use of force or violence. So it's a crime of violence, and Mr. Green is removable. Now, an aggravated felony doesn't per se bar readjustment of status. And it looks like Mr. Green tried to do just that. He tried to adjust LPR status again through his wife, who of course was still an LPR or U.S. citizen. But Hobbs Act robbery is almost surely a crime involving moral turpitude, and so, inadmissible, Mr. Green needed an INA Section 212H waiver. As an aside, even with the aggravated felony, he remained eligible for the waiver because he didn't initially enter the United States as an LPR. And that quirk is due to the strange way that the Section 212H statute is written, and a decade-long legal dispute that concluded a few years ago with the BIA rolling over and agreeing with the other circuits. In order for an aggravated felony to bar an individual from a Section 212H waiver, essentially, the non-citizen needed to first enter the U.S. as an LPR. But read the precedent. Anyway, Mr. Green is eligible. He didn't. He entered some other way and then adjusted to LPR status in the U.S. But the IJ denied the waiver and the BIA affirmed. And usually the circuits couldn't review the denial of a Section 212H waiver. But yet, the 8th Circuit still reviewed whether the BIA, quote, applied the wrong standard of review to the waiver of inadmissibility determination, end quote. That's an important thing in and of itself as we scrape for scraps in this post-Patel jurisdictional world. But the 8th Circuit just didn't see the BIA as having committed legal error. Mr. Green, therefore, lost. Some crimmigration housekeeping before we move on. This week, the 9th Circuit also reaffirmed that Hobbs Act robbery is a crime of violence in the sentence enhancement context, notwithstanding the Supreme Court's Taylor decision. The 5th Circuit reaffirmed similarly with Texas robbery by threat, again, a sentence enhancement case. And not to be outdone, the 3rd Circuit concluded, in the sentence enhancement context, that Pennsylvania robbery is a crime of violence. What a week for robbery and violence. And that is Green v. Garland. Next is Malik v. DHS, published by the Fifth Circuit on August 17th, 2023. And I've got a treat for you all this week. Because initially I was only going to mention this case at the top of the episode. But Ira Kurzban, yes, that Ira Kurzban, believed it so important that he demanded that he come on the show and talk about it to you all. So here we go, a mini interview with Ira about a pretty unfortunate case. And go. Ira, the last time you came on the podcast was when the Supreme Court published the DACA decision 3 years ago. I've discussed, I know, hey, not for lack of asking. And I've discussed like 1,000 cases since then. Why now?
Because I think Malik versus the Department of Homeland Security is one of the most dangerous precedents for practicing immigration lawyers. And for actually any lawyers who ever travel abroad and have their cell phones or laptops with them. It may be in some sense consistent with some other circuit court opinions that suggest a much lower standard because it's a border search, and apparently a much lower standard because it's a border search even if it's a U.S. citizen. But this is really a dangerous precedent. Let me just put it simply. Why is it a dangerous precedent?
Yes.
It's a dangerous precedent for every practicing lawyer, especially immigration lawyers who often travel outside of the United States. If they come back with their cell phones or laptops, because this case is in essence saying the government can seize that cell phone, seize that laptop, and do a forensic search on it. And they don't need probable cause. So your clients, not only is your personal information and your personal life now fully exposed to the government, and it's a government in which you are often in opposition to. In other words, you're not just some real estate lawyer who just happens to be stopped right at the border, but you're somebody who litigates or fights with the very people who have now seized your phone. So now they're looking at your personal information. But putting that aside, they're also looking potentially at your client's information. And that puts you in a very difficult position as a lawyer because your client, as Mr. Malik says in the case, could wind up suing you for disclosure of information or malpractice or or you could wind up with a bar charge, etc. Let's be realistic. The Customs and Border Protection, the Department of Homeland Security, and Immigration and Customs Enforcement, while there are many genuine good people working in these agencies, are adverse to you and adverse often to your client. So you're exposing your client and yourself each time you come in the country.
Taking a step back, before you demanded to come on this podcast and talk about this dangerous precedent, I had, of course, identified the case, but I was going to only talk about it at the top of the episode and not get in depth. But now we're going to, of course, get in depth. But before that, I had written this. Tell me if this is the gist. I said the Fifth Circuit affirmed summary judgment against an immigration attorney and U.S. citizen, Adam Malik's lawsuit against DHS, for DHS having seemingly incorrectly believed that he was an arms dealer and seizing and searching everything on his phone without his consent when he entered from a trip abroad. That's how, did I get that right? Is that the gist of this case?
You got that right, except the court also says and concedes a little further on that, well, they did this, even if it turned out, of course, that even if in hindsight, as they say, suggests that the actual connection between Mr. Malik and some arms dealer was, quote, illusory.
So it doesn't matter if they were wrong. What matters is they thought? Is it reasonable suspicion like we learned in Crim Pro or Crim?
No, it's a much lower standard than that. The question is this a routine search or a non-routine search. If it's a routine search, and the Fifth Circuit kind of says this is a non-routine search,
I hope so.
They kind of suggest it could be a routine search too. If it's a routine search, they need nothing. It's just a border search. They don't need probable cause. They don't even need reasonable suspicion. If it's a non-routine search, then they need reasonable suspicion. And they said, as the district court said, and they agreed, that the fact that they thought that there was some relationship because of the same last name, that there was some relationship with an arms dealer, when I'm sure they had enough information in their own databases to know Mr. Malik was not an arms dealer, but an immigration attorney. But nevertheless, they say, give us your phone.
But they're not saying it's a routine search. I mean, we haven't gotten to the point where
Right.
CBP can just search the phones of U.S. citizens coming back, or have we?
Oh, they can if they.
If it's it's not routine. I mean, they have to have reasonable suspicion. They have to have something.
Right.
But it
Right.
can be wrong. And
No.
no.
Wait. Let's be clear. If it's a routine search, in other words, they decide one day we're going to search everybody coming in, and we're going to search their phone. In other words, we're not somehow picking you out and simply saying we're going to do a routine search of everyone coming in on this flight because they're coming in from a certain country and we think there are problems and so forth. Could they seize everyone's phone? Maybe. It's not clear from this decision that they're saying that they couldn't do that, but they are saying, well, in this case, since it was a non-routine search, they had reasonable suspicion. If it's a non-routine search, they need reasonable suspicion. If it's a routine search, they need nothing,
right,
according to them. And the Constitution allows the government to seize any property at the border. So the interesting question, of course, here is we're dealing with U.S. citizens.
Yeah.
I've always thought it was kind of interesting that they could even stop and question U.S. citizens at the border. And often we've given clients advice, you're a U.S. citizen, unless they're questioning you about your illegal entry or not, you don't have to answer any questions.
Well, you still don't. I mean, what is the punishment if you're not under criminal investigation? But whether they can now seize your phone against your will. I mean, Mr. Malik did everything right if you want to protect your client confidences and you don't want to answer questions. And he even files suit days after this happens saying, give me back my phone. I'm not an arms dealer. Stop looking at it. And oh, by the way, he's getting like texts and messages from his clients while this is going on, while he has a federal lawsuit and a request for an injunction pending. And I don't understand how that doesn't succeed, and how, as the Fifth Circuit says here, DHS doesn't even have to delete the information that it got, even though everybody recognizes he's not an arms dealer. Can you explain that to me?
Yeah, because they say even if in hindsight it turns out not to be accurate, their initial seizure and their initial search of the phone allows them to do what they did, because there's no constitutional right, according to the Fifth Circuit. There's no constitutional right to have the agency, in effect, erase whatever information it had. And the way they got around it, I mean, I think in a common sense way, what you're really saying is, at some point they clearly know that Adam Malik is not an arms dealer, but an immigration lawyer in Houston, Texas, right? I mean, so why didn't they stop at that point? And the court's opinion is saying that you have no constitutional right to expunge, and that's ultimately how they characterize what Mr. Malik was doing, to expunge through an injunction what the government obtained as information.
I mean, really, it sounds like we need a 21st century right to privacy precedent out of the Supreme Court. I mean, what is the right to privacy now? Technology has gone so far afield that it seems like we've got precedent from the 1960s, 1970s, and you're trying to apply it to cell phones that have an entire life inside it. And maybe is that how the Fifth Circuit gets around all of this, saying that there's no constitutional right to the privacy, even for an attorney with attorney-client, which of course is different than constitutional rights, but that's a whole nother protection.
Well, they try to minimize what Mr. Malik was arguing. They say Malik argues that we should extend Riley versus California to border searches.
And that's pretty recent.
But Riley clearly says you don't have the right just to, they understand technology in the Supreme Court, and they understand, how this is a major invasion of privacy, because they understand that most people have a good part of their life on their cell phones or on their laptops. And Malik argues correctly, why isn't this extended in this situation, particularly to a U.S. citizen?
Right.
Malik argues that, but Riley does not require either a warrant or reasonable suspicion. They say, quote, routine cell phone searches at the border, our sister circuits have said, notwithstanding Riley, does not require either a warrant or reasonable suspicion. So all they say is other circuits have reached a conclusion that Riley doesn't apply at the border. They look at the border search as somehow sacrosanct. And that might make sense if the person wasn't a citizen of the United States. That is, we do treat people at the border differently.
Thoracicum.
Right. We do. Well, thoracicum, I think, is really.
Are you agreeing with Alito? Are you agreeing with Justice Alito, Ira? Is that what you're agreeing with Justice Alito?
Thoracicum is really about the writ of habeas corpus and how far it extends and so forth. And under a very peculiar reading of 200-year history.
But we digress.
200-year history of habeas corpus as explained by Justice Alito. But putting that aside, the issue here is why are we treating U.S. citizens the same way as we would treat others when it comes to their personal information? This comes from very old notions about, you're bringing in contraband, you're bringing in a box of cigars from Cuba, and you're not allowed to do that, or a bottle of liquor from North Korea or something, and you're not allowed to do that. And so we have the right to seize that. That's a very different notion, it seems to me, than seizing somebody's life history, their personal information, the information of their clients. And of course, the Fifth Circuit really doesn't address that, other than to say other circuits have found that there is, that any constitutional right doesn't extend any further, like Riley, because it's at the border.
Being the court watcher that I am for the podcast, it does seem like this also might be a case of bad facts make bad law. A lot of these criminal cases that I kind of scan every week, they often they're often U.S. citizens with child pornography on their phone, right? And so circuits are going to bend over backwards to not exclude child pornography and to permit cell phone searches of horrific sex offending adults. But, that's just the old adage, bad facts make bad law, I guess.
This clearly is a different circumstance. And, the court does say, well, they say screen the files for privilege, but who knows what they did? We don't know. And certainly Mr. Malik doesn't know
right.
what was actually screened or not, what can be used later against him. And he raises all these arguments. I mean, it's not as if he didn't raise them. The court's opinion, though, does no justice to his declaratory judgment action and says he lacks standing to bring a declaratory judgment action. They rejected his claims that the government's possession of confidential information is continuing harm. They rejected his claim that he may face disciplinary action by the state bar. He may be exposed to tort claims by clients for breach of fiduciary duty. They dismiss all of these because they say that a declaration would not redress the search. I find that almost unbelievable. Of course, a declaration, because of a person who they recognize is an immigration lawyer who often requires, as it says in the opinion, often requires international travel. So obviously he's submitting this declaration to say in the future,
right,
I want some protection.
He wants a declaratory judgment from the court.
Right. And they say, no standing on that. And then they turn to the injunctive relief. And of course, in the injunctive relief, they do what I said, which is they say, well, first of all, if this was a routine search, you don't need anything because it's the border. And if it's a non-routine search, well, they had more than enough of reasonable suspicion because he had the same last name of somebody who's an arms trafficker. That's all the opinion says. And yeah, it's true in hindsight that was all illusory because it was clear that this was an immigration lawyer and not an arms trafficker, but too bad. And by the way, let me take your example when you said, well, bad facts make bad law. This clearly, obviously wasn't bad facts,
right,
as we can tell. But let's even take the bad facts case. There's nothing to prevent the government from saying we have probable cause because this guy, went to Thailand and has a history of child pornography, or we have other information, and going and getting a warrant and then seizing the laptop. That's a very different circumstance, it seems to me, than just saying you can seize anybody's personal history simply because you're at the border. That's what they're ultimately saying. And that the Constitution somehow stops at the border. This whole idea, this fictional idea that the border somehow means something far more than it actually does. And, the reality is this has been the bane of immigration law for 200 years, between excludable and inadmissible aliens versus, people who are in the country. And the reality is that our borders are not what borders were 200 years ago. People fly in and out. We have hundreds of millions of people coming in and out of the United States each year. We don't have a border in the concept of, like Donald Trump's wall, that they're building you got to climb over this wall to get in, and somehow it's a sealed border. So the whole notion that if your plane is just landing, but you haven't gone through CBP's inspection,
right,
that somehow you're not in the United States. It's a legal fiction. We recognize it as a legal fiction, and yet we give that legal fiction incredible importance, in this case, for absolutely no reason. And for a reason that actually deprives Americans of their right to privacy, as you pointed out, their right to property, and some kind of security in the information that they have about their personal lives, and in this case, about their clients.
So this has been pretty negative, but we knew that going into it. There are positive non-citizen friendly cases this week on the podcast, by the way, but by the time this case will publish, I will have already gotten through them because I've already put them in order in my outline. But I guess to end on a bit of a positive note, if there is one, what do we do, immigration attorneys?
There is a positive note, which the court strikes down. He says, Mr. Ma calls to our attention a district court decision, United States versus Smith, which is from, of course, the Southern District of New York. It's a May 11, 2023 case, 2023 Westlaw 3358357 at page 7, where the judge says U.S. citizens, in fact, do have rights And you can't seize their phone without a warrant, absent exigent circumstances. So we have that one case out there. It's true we have some bad precedent in some of the circuit courts, but we do have at least this one precedent, which Mr. Malik, I think, intelligently cited. And it says, look, you can't seize American citizens' phones or laptops unless you really have an exigent circumstance to do that at the border. And generally, you don't.
So to summarize, we have to fly into LaGuardia and then transfer to whatever city you live in. That's the solution for immigration attorneys.
Apparently, or even better, don't take your cell phone.
How can you not take? Ira, I work for you. What would you do if I didn't take my? What would I do? What would you do if I didn't take my cell phone on my vacation?
Take a burner phone.
Yeah, without access to my work email.
Yes, take it. Yes, it's time. It's time. And even if you have your email, delete everything before you come back into the United States, and just take the emails that are related to the time you're on the trip. I don't know what else to say. No. I mean, you're just exposing clients to enormous risk. We can go back to the former Secretary of Defense under George H.W. Bush, who famously said, I don't want to have any emails, just call me.
Oh, as the millennial, I don't want to have any calls, just email me. to flip it on its head, it is very late on the East Coast. It's even late on the West Coast. Professor Kurzban, thank you for joining us to talk about Malik v. DHS. I wish it could be under better circumstances, and hopefully you come on again soon to talk about a better case.
All right, I'll be happy to. Thank you, Kevin. Your podcast is the best.
Oh yeah,
it's even better than that little blue book that you have.
The 2-volume, 3,000-page book with your name on it. Thanks, Ira. Have a great night.
Be well. Stay safe.
Bye. And that is Malik v. DHS. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. Welcome back. It's been a minute. 2 more to go. First with Kolov v. Garland, published by the 6th Circuit on August 18th, 2023. This case is about adverse credibility. Mr. Kolov is from Bulgaria. He entered the United States in 1999, but he was eventually removed in 2012. He re-entered in 2014 and was apprehended by DHS. But he expressed a fear of returning to Bulgaria based on the fact that he was a member of the Roma ethnic group. He described various incidents of harassment and assaults and was then provided the opportunity to make his case before an immigration judge in withholding-only proceedings. He was deemed to have a reasonable fear of persecution or torture following reinstatement. In immigration court, he filed a Form I-589 application with a declaration, as applicants are apt to do. But in addition to everything that he told the asylum officer, in his sworn statement, quote, for the first time, Mr. Kolov also described an incident from November 2013. He explained that he and friends had left a restaurant when 4 Bulgarian men began harassing them for being Roma. One of the men spit on Mr. Kolov and tried to punch him, causing Mr. Kolov to trip and fall to the ground because he attempted to avoid being hit. While he was on the ground, the 4 men repeatedly kicked Mr. Kolov, causing his nose and lip to bleed. He went to the emergency room, but he was told that his injuries did not require treatment, end quote. He didn't file a police report because he thought that it would be ignored. Then at his eventual immigration court hearing, Mr. Kolov testified to all of that, and what he told the asylum officer, and then additionally, that in May 2012, there was an incident where he was called derogatory names, and he was punched to the ground and kicked. That was the first time he'd ever mentioned that incident. He submitted corroborating statements. When asked on cross-examination why he hadn't mentioned the two events during his reasonable fear interview with an asylum officer, Mr. Kolov said that he was scared and stressed out during his detained interview with immigration police. He couldn't really explain why he hadn't mentioned that final incident, though, in his written asylum statement filed with the immigration court. And for these reasons, the IJ believed that Mr. Kolov was not credible. The BIA affirmed, immigration really requires consistency across multiple testimonies, often spanning multiple years, about events many years in the past. The Sixth Circuit affirmed the BIA. But not before issuing a non-citizen-friendly ruling in accordance with the 10th Circuit, but contrary to the 5th and 2nd Circuits. The 6th Circuit has jurisdiction to review an IJ and the BIA's denial of withholding of removal and cat protection in withholding-only proceedings. This is the whole issue discussed a few weeks ago in Aristegui Maldonado v. Garland, published by the 10th Circuit on August 1st. The issue is that the INA tethers circuit review to final orders of removal. The Supreme Court recently said in Nasrallah and Guzman-Chavez, in other contexts, that withholding of removal and cat denials are kinda separate from the actual final order of removal that's being issued. Withholding and cat protection just withhold or defer that final order of removal. Ipso facto, OIL is arguing across the circuits, the final order of removal in withholding-only proceedings is not the denial of withholding or cat protection, but is instead that final order of removal that is often many years old that is now being reinstated by DHS. Complicated stuff. But as final orders must be petitioned for review 30 days after their issuance, as OIL argues a bit cruelly, literally no withholding or cat applicant in withholding-only proceedings can ever obtain federal court review of the BIA's denial following reinstatement. A nearly categorical bar that is found nowhere in the INA. The 5th Circuit and the 2nd Circuit have bitten post-Nasrallah and Guzman-Chavez. The 10th Circuit almost did, and the 6th Circuit almost did too. But it didn't. And to be fair, OIL actually was pretty merciful in this case and withdrew its jurisdiction argument after the Supreme Court published Sento Zachariah, arguing that the 30-day deadline is merely a claims processing rule that the 6th Circuit can actually waive. Still all tethered to that final order of removal, but now it's not absolute. Still the quite precarious situation for non-citizens if agreed with, but also remember OIL's position in the other circuits going forward where this argument will surely be made. The 6th Circuit didn't address that and focused exclusively on jurisdiction. And although the 6th Circuit seems a bit sympathetic to OIL's precedent-expanding argument, the court held that it, quote, remains bound by circuit precedent permitting review of BIA orders on withholding only and cat relief in these circumstances, end quote. Namely, quote, an order about withholding of removal functions as a reviewable final order because such relief could foreclose an avenue of deportation if granted, end quote. So the 6th Circuit can review, just like the 10th Circuit. On to adverse credibility, affirmed. To the 6th Circuit, quote, the thrust of Mr. Kolov's argument is that the omissions did not directly contradict his later testimony and thus cannot be the basis of an adverse credibility finding, end quote. And that the BIA's finding violated 6th Circuit precedent. But that's not how the 6th Circuit reads its prior precedent, namely Liddy v. Gonzalez from 2005. In that case, the applicants had, quote, wrote in their application that they had taken part in numerous anti-government activities over the course of 6 years, intimating that they could not recount each occurrence of government retaliation in response to their long history of political protest, end quote. So because of that, because their asylum application was vague, when they testified with more specificity at their hearing, that wasn't contradictory. Here, in contrast, and really just showing the absurdity of asylum affidavits, the court explained that Mr. Kolov's asylum affidavit and application, quote, cataloged specific incidents, end quote. So when he added more during his testimony, well, that was too inconsistent for the court. To paraphrase the Sixth Circuit, be more vague in your asylum applications, people. At least that's how I read this. This is not legal advice, but I'm not sure how else to square it. Mr. Kolov's, quote, testimony did not simply add form and detail to generalized statements in his written application, end quote. It did more, in a contradictory sense. So the Sixth Circuit affirmed the adverse credibility finding and the denial of relief and protection. Just a little bit more on this very important jurisdictional issue. Just so you know, the Sixth Circuit reads the Fourth Circuit as also being on it and the Tenth Circuit's side here, albeit based on a single footnote in Thomas Ramos v. Garland, published in 2022, episode 93. Judge Murphy concurred in this case to essentially say that he agrees that the court probably lacks jurisdiction and that the Supreme Court should take up the issue, but that the Sixth Circuit's prior precedent hasn't been overruled yet. The jurisdictional stuff is a big deal, and with a widening circuit split based on recent Supreme Court precedent affecting jurisdiction, I bet it'll be at the Supreme Court pretty soon. And looking at what happened in Patel and the broad swath of claims the Supreme Court was willing to make unreviewable there, I don't love the odds for the immigration bar. We'll see. And that is Kolov v. Garland. Concluding with a big one, Aguayo v. Garland, published by the 10th Circuit on August 18th, 2023. This case is about termination and unlawful detention. It's a bit of a rare argument and a rare issue for the podcast. Join me on this journey. Mr. Aguayo is from Mexico and has lived in Utah for over 25 years. He's been in the United States for over 30. He has 4 U.S. citizen children with his wife, and in 2018 his U.S. citizen daughter, by then over 21 years old, filed a Form I-130 petition for him, allowing Mr. Aguayo to apply to become a lawful permanent resident after all these years, in 2019. By the way, despite his illegal entry in 1992, Mr. Aguayo was INA Section 245I eligible because his brother had filed an I-130 petition for him on March 23, 2000, over a year before the INA Section 245I deadline, therefore not requiring an inspection and admission. A whole other issue for another day, but suffice it to say, good on you, Mr. Aguayo and counsel. Tragically for Mr. Aguayo, though, in 2019, he was arrested by Utah police and charged with 2 counts of possession of a forged document, use or possession of drug paraphernalia, and having an open container in a vehicle. He really messed up. He also had other pending charges, and this is all while that I-130 and I-45 adjustment application are pending. While in state custody, ICE placed a detainer hold on him, meaning that even if released from state custody, Utah police should essentially give ICE a heads up first and hold Mr. Aguayo for a few more days to permit ICE time to pick him up and place him in ICE prison. That is, provided the Utah sheriff believes that ICE detainers are constitutional and that the sheriff complies with them. Seems like the sheriff does. Mr. Aguayo remained in state custody for 5 months while all the criminal stuff played out, and eventually pled guilty to some charges that probably make him removable and inadmissible, therefore barring him from adjusting to LPR status. We'll see. Mr. Aguayo wasn't in removal proceedings by this point, though. The adjustment and I-130 matters were still pending before USCIS. Quote, about 12 hours after the state court ordered Mr. Aguayo released, the Utah County officials transferred Mr. Aguayo to ICE custody, end quote, because of that ICE detainer hold. Then he was transferred to an ICE facility in Utah and served with a notice to appear, kicking off removal proceedings. An incorrect MTA, by the way, it said he was in Seattle. The IJ found Mr. Aguayo's conviction was a CIMT and not only made him removable, but subjected him to mandatory detention without bond. And to be fair, he was also removable because he had entered without authorization in 1992. Worse still, that I-130 filed by his daughter hadn't been approved yet, and in detention, well, he couldn't make that USCIS interview to prove that he was his daughter's father. So USCIS denied the I-130 petition. That's just absurd, I must say. One DHS sub-agency denying a clearly approvable visa petition because another DHS sub-agency was detaining Mr. Aguayo? And CIMT aside, without an approved visa petition, Mr. Aguayo has no chance of adjusting to LPR status because he doesn't have a petition. Faced with all this, Mr. Aguayo moved to terminate his removal proceedings, alleging a slew of constitutional and regulatory violations tethered to ICE's actions with the Utah police that led to his detention. To sum it up, quote, according to Mr. Aguayo, ICE's violations over a 12-hour period caused his unlawful detention, which resulted in his inability to participate in his status adjustment interviews and the ultimate denial of his visa application, end quote. Mr. Aguayo argued that all of that violated ICE's own regulations and Mr. Aguayo's constitutional rights, and that all of it prejudiced him in various ways, as motions to terminate generally require. Stepping back and without getting into all of the very complicated allegations underlying the motion to terminate, remember, ICE did extend his state custody by like 12 hours without even filing a notice to appear. For example, that's clearly a 12-hour seizure, potentially protected by the Fourth Amendment. And in one of my favorite arguments to use, quote, Mr. Aguayo also asserted prejudice could be presumed under the BIA's decision in matter of Garcia Flores from 1980 because the regulations violated were mandated by the Constitution, end quote. That is, the regulations violated were implemented by the U.S. government to protect non-citizens' constitutional rights, so when violated, no prejudice need even be shown for a non-citizen to get relief. And IJ and then the BIA disagreed. It's really complicated. So I'm going to just skip to what the 10th Circuit ruled. It was against Mr. Aguayo. But don't let Attorney General Sessions or BIA dicta fool you. Even OIL agrees that, quote, termination of agency proceedings is warranted under certain circumstances, end quote. For example, in the 9th Circuit, termination is appropriate even if removability can be established where, quote, 1, the agency violated a regulation, 2, the regulation was promulgated for the benefit of petitioners, and 3, the violation was egregious, meaning that it involved conscience-shocking conduct, deprived the petitioner of a fundamental right, or prejudiced the petitioner, end quote. Similarly, in the 2nd Circuit, quote, regulatory violations occurring during a deportation hearing that affect fundamental rights derived from the Constitution or federal statutes require termination, end quote. The 10th Circuit assumed that all of that was correct, without actually deciding it. Now, in that space, matter of Garcia Flores from 1980 is one of the very important cases to rely upon where your argument is for termination based on ICE violating its own regulations. According to the test laid out by the BIA in Garcia Flores, quote, a petitioner must show 1, the agency violated a regulation that serves a purpose of benefit to the non-citizen, and 2, the regulatory violation prejudiced interests of the non-citizen which were protected by the regulation, end quote. 43-year-old decision, that's still good law. But the 10th Circuit didn't see either Garcia Flores prong met in this case. First, the second Garcia Flores prong, prejudice. The 10th Circuit didn't believe Mr. Aguayo prejudiced just because he had to litigate these issues and his LPR eligibility in adversarial removal proceedings rather than in an ostensibly non-adversarial setting before USCIS. Mr. Aguayo had the opportunity to present all evidence required in immigration court. That he was cross-examined by an ICE trial attorney doesn't change that for prejudice purposes. And I guess I'm missing something. I guess USCIS must have ultimately approved a second I-130 petition filed by Mr. Aguayo's daughter, because if they hadn't, he'd totally have been prejudiced by being detained, because he wouldn't have been able to even apply for adjustment of status, because again, absurdly, IJs lacked jurisdiction to approve a Form I-130 petition. So let's just assume that USCIS did approve a second I-130 petition even though he was detained, else I don't see how this decision makes sense. Okay, fine, no prejudice. But Mr. Aguayo also argued that the 10th Circuit should presume prejudice because, quote, the violations at issue disrupted the entire procedural, statutory, and regulatory framework, end quote. That's Garcia Flores again. Love it. Rejected. But again, indeed, quote, prejudice may be presumed under Garcia Flores when the agency violates a regulation, 1, where compliance with the regulation is constitutionally required, or 2, where the regulation is part of a structure guaranteeing fair proceedings, end quote. Those are expansive quotes and powerful arguments if you can get them. But here, the 10th Circuit didn't believe that Mr. Aguayo had actually shown that the broad array of regulatory violations that he alleged ICE committed were actually designed to ensure Fourth Amendment protections rather than simply providing a framework for ICE to use when detaining non-citizens and prosecuting removal proceedings. Still mandatory, and still can be grounds to terminate if violated, but only if prejudice is shown, said the 10th Circuit as regards these regulatory violations. Pretty harsh. Now, old Supreme Court precedent, recognized by most if not all of the circuits, also would permit termination, prejudice or not, where ICE committed egregious constitutional violations. But the 10th Circuit didn't see that here either. Even if, as Mr. Aguayo alleged, ICE took him into detention from state custody without issuing an actual ICE warrant, and even if that was a regulatory or even constitutional violation, the 10th Circuit didn't believe it was egregious enough. It didn't, quote, shock the conscience, end quote, to the court. That is, 12 hours of imprisonment without a warrant or probable cause of criminal conduct. Historically, and as the 10th Circuit kind of recognizes, the egregiousness argument often travels better, where you can show that the ICE or other law enforcement conduct was based on race. That's not necessary, but it is the more traditional argument to the extent that you can call any of this traditional. And it's not settled in the 10th Circuit. So, lots of smart arguments made by smart law students, pro bono attorneys, and non-pro bono advocacy on this one, but unfortunately for Mr. Aguayo, it did not succeed. And that is Aguayo v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.